$216,412. That's what was left of my husband's inheritance the day I finally saw the real numbers. Not the numbers his parents showed us at Thanksgiving, printed on a single sheet of paper they'd pass around the table like a report card. The real numbers. The ones sitting in 6 years of bank statements, trust ledgers, and a forged signature that a notary public stamped without ever seeing my husband's face. $216,000. Gone. And the strange part, the part that still makes my stomach drop when I think about it, is that the theft wasn't hidden behind lies about being broke or sob stories about medical bills or some elaborate con run by a stranger. It was hidden behind Christmas ornaments, behind Easter egg hunts, behind a mother-in-law who cried real tears if we so much as mentioned spending one Thanksgiving with my side of the family instead of hers. For 6 years, my in-laws demanded, not asked, demanded that we spend every single holiday under their roof. Every 4th of July, every Thanksgiving, every Christmas morning, every birthday, anniversary, and just because Sunday dinner. And for 6 years, I thought it was about love. Obsessive, controlling, exhausting love, but love. It wasn't love. It was surveillance. They needed us close. They needed eyes on us constantly, so we'd never have the time, the distance, or the outside perspective to ask the one question that would unravel everything. Where did Grandma Eleanor's trust fund actually go? The first Christmas we didn't show up, the first one in 6 years of marriage, wasn't a rebellion, it wasn't a statement. We were exhausted new parents who just wanted one quiet morning in our own living room with our own 6-month-old daughter. That's all it was supposed to be. But the moment we said no, something in my mother-in-law broke. And what came pouring out of that crack was the beginning of the end for both of them. They thought they got away with it. They were wrong. Hey, welcome back. If you're new here, this channel is about exactly this. Greed, betrayal, and the very satisfying process of netting every single dollar back from the people who thought they'd never get caught. Today's story involves a family trust, a forged notarization, a fake trustee amendment, and 2 in-laws who used the illusion of a close-knit, holiday-obsessed family to hide a 6-year financial crime against their own son. If you've ever had that gut feeling that something in your family didn't add up, the guilt trips that felt a little too convenient, the you have to be here's that felt more like control than love, you are going to want to watch this whole thing. Because by the end, I'm going to walk you through exactly how we found the smoking gun, exactly how we built the case, and exactly what it took to force 2 people who raised my husband to write a 6-figure check with interest. Hit subscribe if you want more of these. Real financial fraud stories, real investigations, real justice. Let's get into it. My name's Megan. I'm going to change a few identifying details here. Names, exact locations, the name of the town, because there's still an active judgment being collected on, and I don't need to make that harder than it already is. But every number, every document, every event in this story is real. I met my husband, Daniel, in 2016. He was easy to love, steady, funny, the kind of guy who calls his mom every Sunday not because he has to, but because he wants to. I liked that about him. I liked his family, too, at first. His parents, Carol and Frank, were warm in that loud Midwestern holiday sweater way. Big dinners, bigger opinions, the kind of house where every surface had a framed photo on it. What I didn't know yet, what Daniel himself barely understood, was the shape of his financial history. Daniel's grandmother, Eleanor, had been wealthy in a quiet, unglamorous way. She'd owned rental property in 3 states, invested conservatively for 40 years, and never once talked about money at the dinner table. When she passed away in 2015, a year before Daniel and I met, she left behind an estate that included a trust, funded initially at just over $310,000, set up specifically for Daniel. Not for Carol, not for Frank, for Daniel, and eventually for any children he had. The trust had a simple structure on paper. Carol and Frank were named co-trustees until Daniel turned 30, at which point the trust was supposed to either transfer full control to Daniel or distribute according to Eleanor's instructions, whichever the original trust document specified. Daniel was 23 when his grandmother died. That gave his parents 7 years of legal control over a fund that wasn't theirs. I want you to sit with that structure for a second because it matters later. 7 years, full trustee authority, a 23-year-old beneficiary who trusted his parents completely and had no reason, none, to ask for quarterly statements or oversight. Here's the first red flag, and it's one I didn't even register as a red flag until years later. Daniel had never actually seen the trust document.
He knew it existed. He'd been told, vaguely, Grandma left you something, it's being handled. His parents talked about the fund the way you'd talk about a savings bond tucked in a drawer somewhere. Real, but not urgent, not something you needed to look at. When we got married in 2018, I asked Daniel, half joking, whether we should look into that inheritance for our future. He shrugged. My parents have it handled. They're not going to steal from me, Megan. And I believed that, too. Why wouldn't I? These were people who hosted 40-person Thanksgivings and cried at every wedding toast. They didn't look like people capable of quietly bleeding their son's trust dry. But looking back now, with everything I know, I can point to at least 4 moments in those early years that should have made both of us pause. Red flag 1. Carol and Frank renovated their kitchen in 2017, a full gut renovation, quartz counters, a $14,000 range, right after a year where Frank's small business, a specialty flooring company, had what he called a rough patch. At the time, I thought, well, maybe they had savings. Maybe it was a home equity loan. It didn't occur to me to ask where a rough patch year suddenly produced $14,000 in discretionary renovation spending. Red flag 2, every single holiday gift Carol and Frank gave, to us, to their other kids, to grandkids, to extended family, was extravagant. Not just generous, extravagant in a way that didn't match what Daniel understood about his parents' income. Frank's flooring business was solid but modest. Carol worked part-time at a dental office. And yet Christmas mornings looked like something out of a department store catalog. Again, I noticed it. I even remember saying to Daniel once, "How do you parents afford all this?" And he said the things so many of us say about our own families. I don't know, they've always been like this. Red flag 3, anytime Daniel and I so much as floated the idea of spending a holiday with my side of the family, instead, my parents live 4 hours away, Carol's reaction was wildly disproportionate. Not disappointed, not, "Oh, we'll miss you," devastated. Calls where she cried, guilt-laden voicemails about how family is supposed to be together and how she didn't raise Daniel to abandon her mother. One year, when we tentatively suggested alternating Thanksgivings, Frank actually said to Daniel, in a tone that still gives me chills now, "You don't know what you'd be giving up." At the time, I read that as controlling parenting, a boundary problem, a mother-in-law thing. I did not read it as a man protecting access to money. Red flag 4, the one that haunts me the most, Carol and Frank insisted on hosting every gathering at their house. Not a rotation, not a let's meet halfway. Always their house, their kitchen table, their calendar. And every visit came with what I can only describe now as gentle debriefing. Questions about our finances, our jobs, whether we'd started thinking about the future, whether we'd talked to a financial advisor yet. I thought it was nosiness. It was reconnaissance.
I want to give you one specific scene because I think it captures the dynamic better than any general description can. 4th of July, 2019. Daniel and I had, for once, been invited to a friend's lake cabin, not Carol and Frank's lake house, this was years before that even existed, for a proper long weekend. We told Carol about it 2 months in advance, plenty of notice, framed gently. We're going to miss the 4th with you guys this year, but we'll do a big dinner when we're back. Carol didn't yell. She did something that, in hindsight, was more effective and more telling. She got quiet. She started referencing in almost every phone call over the following weeks how hard it's been lately and how she just needed her family around her right now. without ever specifying what exactly was hard. When we gently asked what was going on, she'd deflect. "Oh, nothing, don't worry about it, you go have fun," in a tone specifically engineered to make going have fun feel impossible. We canceled the cabin trip. We spent the 4th of July at Carol and Frank's house, like always. At the time, I remember feeling proud of myself for being a good daughter-in-law, for prioritizing family. Looking back now, I recognize that scene for what it actually was, a controlled test of whether we'd hold a boundary, followed by an emotional lever pulled the exact moment we tried. Carol never had to say, "Don't leave, I need to keep an eye on you." She just had to make leaving feel like abandonment, and we'd fold every single time. We did this, some version of this, probably a dozen times over 6 years. Weekend trips canceled. My family's holidays quietly deprioritized year after year without either of us ever quite deciding to do that. It just kept happening, one guilt-soaked phone call at a time. A vacation to visit my college roommate rescheduled twice because it landed too close to family time. A standing joke between me and my own mother, tinged with real hurt underneath the joke about how Megan belongs to the other family now. None of it on its own looked like fraud. Controlling in-laws are unfortunately common enough that most of the people I've told this story to just nodded along at that part, recognizing it from their own lives. That's exactly what made it such effective cover. Nobody looks twice at a mother-in-law who wants her son close. Everybody looks twice at bank statements. Carol and Frank, whether they consciously understood the mechanics of what they were doing or not, built a system where the first kind of behavior made the second kind of behavior invisible. In 2021, Daniel turned 30. Under the terms of his grandmother's trust, which neither of us had read because it lived in a manila folder in Carol and Frank's home office, that birthday was the legal trigger point. The trust document specified that upon the beneficiary's 30th birthday, the co-trustees were
required to either distribute the trust in full or transfer trusteeship to the beneficiary, whichever Eleanor's attorney had structured. Nothing happened. No conversation, no mention of the trust at all that year, actually, which in hindsight is its own red flag. The one year they should have brought it up was the one year they went completely silent about it. Daniel didn't think anything of it. He was 30. We'd just had our daughter. We were sleep-deprived and consumed with a newborn. The trust wasn't on either of our minds. His parents knew that, and I now believe, with everything I've since learned, that they were counting on exactly that kind of distraction. By this point, according to what we'd later uncover in the bank records, roughly $130,000 had already quietly moved out of that trust account 3 years before we had any idea anything was wrong. That's Act 1, a trusted family, a trust fund nobody looked at, a legal deadline that came and went in total silence, and a pattern of holiday obligation that at the time just looked like love. It wasn't until the Christmas we finally said no that any of us started asking the right questions. November 2023. Our daughter, Poppy, was 6 months old. Daniel and I were running on fumes, new parent fumes, the specific kind where you can't remember the last time you finished a meal while it was still hot. Carol called, as she did every year in early November, to lock in the holiday schedule. That was her actual phrase, lock in, like we were negotiating a lease. Thanksgiving at their house. Fine, we said, we always did that. Christmas Eve at their house. Christmas morning, and this is where I finally hit a wall I didn't know I'd been building for 6 years. Christmas morning also at their house because Carol wanted to see Poppy open her first real Christmas presents. I looked at Daniel, he looked at me, and for the first time in our marriage, we said gently that we wanted to wake up Christmas morning in our own house with our own daughter and come over for a late lunch instead. I want to be really clear how mild this boundary was. We weren't skipping the holiday, we weren't cutting them off, we were asking for one single morning, 6 hours, in our own house before joining them in the afternoon. Carol's reaction was not proportional to that request, not even close. She didn't answer at first. Then came a text 20 minutes later that read, "I see. I guess I understand if we're not important enough anymore." Then a call from Frank, tight-voiced, saying Daniel was choosing his wife's family over his own, which we hadn't even mentioned my family. We were staying home. Then, 3 days later, an hour-long phone call from Carol that
ended in tears, in which she said something that at the time I thought was just guilt-tripping theater. She said, "After everything we've done for you and your family, Daniel, this is how you repay us?" Everything we've done. At the time, I heard that as generic parental guilt language. In hindsight, it was almost a confession. Because what exactly had they done that warranted a six-figure emotional debt? Hosted dinners? It doesn't usually come with this level of financial-sounding language. We held the boundary. We spent Christmas morning, our first one ever, alone in our pajamas, watching our daughter stare in confusion at wrapping paper. It was, honestly, one of the best mornings of my life. It was also the morning everything started to unravel for Carol and Frank, though none of us knew it yet. We went over for that afternoon visit, as planned. The mood was frosty. Carol was doing the thing she did when she was upset but wanted credit for being the bigger person. Overly polite, overly formal, a performance of graciousness, with the temperature turned way down. At one point, Frank and Daniel were in the garage. Frank always found reasons to pull Daniel into the garage for man talk. And I was in the kitchen with Carol, who was scrubbing a pan that didn't need scrubbing. She said, not quite to me, more to the pan, "We've given that boy everything. Every bit of that fund has gone right back into this family. And this is the thanks we get." That fund. I actually stopped what I was doing, because Daniel and I had never discussed his grandmother's trust with Carol in front of me. I knew it existed the way you know your neighbor has a pool you've never seen. An abstract fact. But Carol had just referred to it, unprompted, defensively, in a tone that suggested she'd been thinking about it a lot more than handled implies. I didn't push. I filed it away, but it sat in my stomach like a stone the whole drive home. That night, I asked Daniel, "Have you ever actually seen your grandmother's trust paperwork?" He hadn't. Not once. Not in 8 years since Eleanor died.
We did the reasonable thing first. We didn't jump to accusations. In January 2024, Daniel called his parents and asked calmly if they could send over the trust documents and maybe a recent statement, just so I understand where things stand since I'm 30 now. The response was immediate deflection. Frank said the paperwork was with the accountant and he'd have to track it down. Carol said it was not a big deal, everything's fine, why does this feel like an attack? When Daniel followed up 2 weeks later, Frank said the accountant was swamped with tax season and it might take a while. By March, after 3 more requests, we still had nothing. Not a statement, not a copy of the original trust, not even the name of the financial institution holding the funds. That's when Daniel, for the first time in his life, said the sentence that changed the direction of this whole story. Something's wrong. Here's what we didn't know yet, but would piece together over the following months. Carol and Frank hadn't just been slow to respond. They'd been actively managing a 6-year drawdown of a fund that was never theirs to spend, and by early 2024, they knew the excuse window was closing. We'd later learn that in the 2 months between Daniel's first request and Carol's "everything's fine" phone call, Frank made 3 separate visits to the credit union that held the trust account, visits we only discovered through subpoenaed records. He wasn't gathering paperwork to hand over. He was trying to understand how much of a paper trail existed and whether it could be cleaned up before anyone with legal standing looked closely. He also, we'd discover, reached out to a family friend, a notary public named Denise, who'd known Carol for over a decade through their church, about witnessing a signature update on some old paperwork. At the time, we had no idea this conversation had even happened. It would become one of the most important pieces of evidence in the entire case. Meanwhile, the emotional pressure campaign about the holidays didn't stop. If anything, it intensified. Carol started calling more often, inviting us to just come by, no big occasion, in a way that felt less like affection and more, I now realize, like she was trying to physically monitor how close we were getting to the truth. Every visit came with careful, casual-sounding questions. Had we talked to any lawyers lately? Had we been in touch with Eleanor's old attorney? Had Daniel been stressed about money? We hadn't yet, but we were about to be. By April 2024, 4 months of stonewalling in, Daniel finally did the one thing his parents had spent 6 years subtly discouraging him from doing. He called his grandmother's estate attorney directly.
Before I get into the numbers themselves, I want to name something that doesn't show up on a forensic accountant's ledger: the emotional cost of those 4 months between something's wrong and actually having proof. Daniel stopped sleeping well. He'd grown up believing his parents were, whatever their flaws, fundamentally decent people who loved him. Every day that passed without documents from them chipped away at that belief a little more. And there's a specific kind of grief in slowly realizing your own parents might have been lying to you for the majority of your adult life. He described it to me once as feeling like the ground under an entire childhood was quietly being tested for cracks. I felt something different but related, a kind of retroactive anger on his behalf, replaying 6 years of holidays in my head and recognizing one by one the moments that had felt like love at the time and now looked like management. The Christmas gifts, the extravagant birthday parties, even Carol's tears over that first missed Christmas morning took on a different shape once I understood what might really have been underneath them. Not grief over a missed breakfast, but fear of losing the closeness that had kept her secret safe for 6 years. And there was the marriage cost, too, the kind nobody talks about in these stories. Daniel and I fought, more than once, during those months. Not about the fraud itself, but about how to handle his parents day to day while an investigation quietly built in the background. Do you go to Easter and act normal? Do you let Poppy stay overnight at their house while you're gathering evidence against them? We didn't have a script for any of this. We were making it up as we went, trying to protect our daughter, protect the case, and protect what was left of Daniel's relationship with his parents, all at the same time. And some weeks, it felt like those 3 goals were actively pulling against each other. The attorney, a soft-spoken man named Mr. Alvarez, who'd handled Eleanor's estate back in 2015, still had the original file. And within 10 minutes on the phone, Daniel told something that made the floor tilt under both of us. The original trust, funded at Eleanor's death, held $308,600. The document explicitly stated that upon Daniel's 30th birthday, trusteeship was to transfer to Daniel automatically, with a full accounting to be provided at that time. There was no ambiguity, no fine print giving Carol and Frank ongoing discretion. The plan had been simple and clean, exactly the way Eleanor had always done things. Mr. Alvarez also mentioned something that stopped Daniel cold. Back in late 2021, right around Daniel's 30th birthday, the exact window when the trust should have transferred, his office had received a request from Carol for a notarized amendment, purportedly signed by Daniel, extending trustee control for an additional period pending the beneficiary's request.
Daniel had never signed anything. He'd never even spoken to Mr. Alvarez's office in 2021. He didn't know that office still existed in relation to his affairs. That's when I found the smoking gun. Because a signature can be checked, a notarization can be verified, and a document dated to a phone call that never happened, requesting authority Daniel never granted, isn't a family disagreement anymore. It's fraud. I want to be honest with you about what those next few weeks felt like, because I think anyone who's been through something like this will recognize it. It's not a dramatic movie montage. It's spreadsheets at 11 at night. It's staring at your father-in-law across a dinner table 3 days later, making small talk about the weather, while a document sits in your email proving he forged his son's name.
We hired a trust and estate litigation attorney, a woman named Priya Nair, who specializes in exactly this kind of case, breach of fiduciary duty by family trustees. Her first sentence to us in our very first consultation was something I'll never forget. This is more common than you'd think. Family trustees who never expected to get caught because they never expected their kids to ask questions. Priya laid out our first move clearly. Before we accused anyone of anything, before we said a single word to Carol and Frank, we needed documentation, real documentation. Bank records, the original trust, the notarized amendment, and, critically, a forensic accountant who could trace exactly where the money had gone. Because Daniel was the beneficiary, and per the original trust, should have been the trustee since he turned 30, Priya was able to formally demand a full accounting from Carol and Frank as improperly continuing trustees, a legal right Daniel had that his parents had been quietly hoping he'd never exercise. When they stalled again, no surprise there, Priya filed a petition in probate court compelling them to produce trust records, an accounting, and all associated bank statements going back to 2015. Courts do not like trustees who stall when compelled. Within 6 weeks, we had 4 bankers' boxes worth of statements, and a forensic accountant named Robert, who Priya brought in specifically because he'd testified in trust litigation before, went to work line by line. What Robert found over about a month of tracing was staggering in both its scale and its pattern.
$14,200, the kitchen renovation from 2017. Paid directly from the trust's brokerage account to a contractor, disguised in Carol and Frank's own records as home improvement loan, even though no such loan existed anywhere in their credit history. $31,000 funneled into Frank's flooring business in 2018 during what he'd called a rough patch. Not a loan, not repaid, a straight transfer with a memo line that just said business support. $38,500, spread across 6 years of holiday gifts, family vacations, and special occasion spending for not just Daniel, but Carol and Frank's other adult children and grandchildren too. Every extravagant Christmas we'd sat through, every generous gift that made Carol look like the most loving grandmother in the county, had been bought with money that legally belonged to Daniel alone. $62,000, a down payment on a lake house Carol and Frank purchased in 2020, titled solely in their names. $40,300, the one that stung the most when we found it, quietly wired to Frank's brother, Daniel's uncle, in 2019 to bail out a failing restaurant venture. Nobody in the family had ever known where that money came from. We later learned Frank had told his brother it was an inheritance windfall from Eleanor's estate. Technically true, just not his to give. The rest, roughly $30,000, was untraceable to any single line item, absorbed into general household spending over the years. Car payments, credit card balances, the ordinary bleed of a household quietly living slightly beyond its means and papering over the gap with someone else's money. Total confirmed drawdown from the trust, principal plus lost growth Robert calculated the account should have earned if left invested, $216,412. That's when I found the second smoking gun, because up to this point you could almost construct an innocent explanation. Bad bookkeeping, blurred lines between family and finances. But the pattern Robert laid out wasn't sloppy, it was systematic. Every single withdrawal was structured to stay under amounts that would typically trigger extra scrutiny from the credit union's compliance team, and every one was made in the months immediately following a major holiday, Christmas, Thanksgiving, the 4th of July, when Carol and Frank knew, with total certainty, exactly where Daniel and I would be, exactly how distracted and exhausted we'd be, and exactly how unlikely we were to be reviewing financial paperwork. The holidays weren't just cover, they were functionally part of the operational timing of the theft. The 2021 amendment, the one extending trustee control right when it should have ended, became the centerpiece of the case. Priya subpoenaed Denise, the notary, along with her notarial journal, which by state law she was required to keep, logging every document she'd notarized, the date, and a description of the signer's ID.
Denise's journal had an entry for that date. It listed Daniel's name as the signer. It did not list a driver's license number, which state notary law required. It listed only known personally to notary, the exception notaries can use when they personally know the signer well enough to skip an ID check. Denise had never met Daniel, not once in his entire life. When Priya deposed her, Denise's story fell apart within about 15 minutes. She admitted, tearfully, that Carol had brought the document to her already signed, told her it was just a formality Daniel didn't have time to come in for, and asked her to notarize it as a favor between old friends. Denise hadn't verified anyone's identity because there was no one there to verify. She'd notarized a blank chair. That is not a paperwork error. Under the laws most states use to govern notaries, notarizing a signature without the signer present is notarial fraud, a crime that can carry both civil liability and a referral to a state licensing board. Before we filed anything, Priya recommended one more step that turned out to matter a great deal: talking, carefully and non-accusatorily, to people who'd been close to Eleanor and Carol and Frank over the years, in case there were witnesses who could speak to intent or awareness. We found one almost by accident: Eleanor's longtime next-door neighbor, a woman named Ruth, who'd known the family for 30 years. Mentioned to Daniel at a casual coffee, before we'd told her anything about what we'd found, that she'd always found it strange that Carol used to talk about Daniel's money as though it were a shared family resource, even back when Eleanor was still alive. She'd say things like, "Once we have access to it, we can finally fix up the house," Ruth recalled. And I remember thinking, isn't that Daniel's, not yours? But it wasn't my business to say anything. Ruth agreed to provide a written statement. It wasn't the core of our case. The forensic accounting and the forged notarization did the heavy lifting, but it corroborated something important: that Carol's intent to treat the trust as accessible family money predated Eleanor's death and wasn't some later rationalization she'd talked herself into after years of financial pressure. It had been the plan from close to the beginning. Priya also had us compile a timeline correlating every major withdrawal against our own calendar of holidays, visits, and mandatory family gatherings, the same calendar Carol had spent years enforcing. When we laid the two timelines side by side, the correlation was almost uncomfortably clean. 11 of the 14 largest withdrawals occurred within 3 weeks. A major holiday obligation, the exact windows when Daniel and I were most present, most exhausted, and least likely to be reviewing anything financial. Robert, our forensic accountant, later testified that this pattern was itself circumstantial evidence of intentional timing, not coincidence. Trustees managing funds in good faith don't typically cluster their largest transactions around the beneficiary's least attentive periods. Here's the part of the story that genuinely scared me while it was happening. About 3 weeks after we filed the probate petition, before Carol and Frank had any idea how much evidence we'd already gathered, Priya's paralegal flagged something unusual in a routine title search. Frank had initiated a quitclaim transfer of the lake house into a newly formed LLC, one registered less than 10 days earlier with an address that traced back to Carol's sister's house 2 states away. If that transfer had completed, the lake house, the single largest asset purchased with stolen trust funds, would have moved out of Frank's name and into a shell entity that would have made it dramatically harder to attach in any future judgment. We would have won the lawsuit and had almost nothing left to actually collect. Priya moved fast. Within 48 hours, she filed for a temporary restraining order and a lis pendens, a legal notice recorded against the property that freezes its ability to be sold or transferred while litigation is pending, specifically citing the newly discovered forensic accounting and the timing of the LLC formation as evidence of an attempt to dissipate assets in anticipation of judgment. The judge granted it the same week. Frank's attorney would later claim in filings that the LLC transfer was unrelated estate planning that had nothing to do with our case. The timing, 10 days after we filed our petition, for an asset that represented our single largest recovery target, did not persuade the judge. That near miss is honestly the moment this stopped feeling like a family dispute and started feeling like exactly what it was: a financial crime being actively covered up by people who were still, at that same time, calling us to ask if we were coming for Easter. We did not go to Easter that year.
By June 2024, Priya filed the full civil suit: breach of fiduciary duty, conversion, constructive fraud, and a request for a constructive trust over the lake house and any other assets traceable to the stolen funds. We also formally reported the forged notarization to the State Notary Licensing Board, which opened its own independent investigation into Denise.
We considered pushing for criminal charges too. Priya was upfront that forgery and elder-adjacent trust fraud can, in some states, be prosecuted criminally, not just pursued civilly. We met with an assistant district attorney, laid out the entire forensic accounting package, and were told something that a lot of people going through this kind of case unfortunately hear. The DA's office viewed it as a family civil matter, given the relationship between the parties and the absence of a vulnerable elderly victim. Eleanor, after all, was already deceased when most of the drawdown occurred, and Daniel was an adult. They declined to file criminal charges against Carol and Frank directly. It stung. I won't pretend it didn't, but Priya reframed it in a way that helped. Civil court was where the money actually was. A criminal conviction doesn't put $1 back in your pocket. A civil judgment, enforced properly, does. The notary board, however, did not decline to act. Denise's investigation concluded within 4 months. Her notary commission was revoked, and she was referred for possible criminal charges for the false notarization itself, since, unlike the family trust dispute, notarial fraud against a state licensing statute is much more clear-cut and doesn't hinge on family relationships at all. I wasn't in the room for Carol and Frank's depositions, but Daniel was, alongside Priya. He described it to me afterward as the strangest 4 hours of his life, watching his parents, under oath, forced to answer direct questions about specific withdrawals with a forensic accountant's exhibit binder sitting on the table in front of them. Frank's answers, according to the transcript, followed a pattern Priya said she'd seen many times before: minimization, then reluctant admission, then blame shifting. He characterized the flooring business transfer as a loan we always intended to repay, despite 6 years passing with zero repayment and no loan documentation anywhere. He characterized the lake house down payment as money he was owed for decades of caring for Eleanor, despite Eleanor's own estate plan, drafted by her own attorney, making no mention of any such debt and explicitly directing the funds to Daniel. Carol cried through most of her deposition. At one point, when asked directly why the 2021 amendment existed, she said quietly that she panicked when Daniel turned 30 because she knew the money wasn't going to be enough to explain if he ever looked closely, so she and Frank decided to buy some time. Buy some time. That phrase is functionally an admission that the amendment was manufactured specifically to delay discovery. Not a paperwork mix-up, but a deliberate, timed decision to forge a legal document because they knew the real number wouldn't survive scrutiny. The case settled just before trial, in October 2024, after Priya made clear we were fully prepared to take it in front of a jury with a forensic accountant, a disgraced notary's sworn deposition, a paper trail 6 years deep. Carol and Frank's attorney recommended settlement rather than risk a public trial and an even larger jury verdict. The final judgment: $216,412 in principal restitution, matching Robert's forensic calculation exactly. $38,900 in prejudgment interest, calculated back to the point each withdrawal occurred. $27,000 in attorney's fees and litigation costs, which the settlement required Carol and Frank to cover in addition to the restitution, a provision Priya specifically fought for and won, meaning the theft didn't just get paid back, it got paid back plus the full cost of catching them. Total, $282,312. To satisfy the judgment, the lake house, the one Frank had tried to quietly move into an LLC, was sold, netting a little over $190,000 after the mortgage was paid off. That covered the bulk of the restitution outright. The remainder was structured as a judgment lien against Carol and Frank's primary residence, meaning if they ever sell or refinance that house, the balance comes due automatically, with continuing interest until it's fully paid. Here's the part of this story that I think surprises people most, because it reframes everything you've heard so far. When Robert's forensic report broke down all $216,412,
I assumed, the way I think most people would assume, that the money mostly went to Carol and Frank's own comfort, the kitchen, the lake house, and a lot of it did. But remember that $38,500 in holiday gifts and family generosity, and the $40,300 quietly bailing out Frank's brother's restaurant? That's nearly $80,000, more than a third of the entire theft that wasn't spent on Carol and Frank at all. It was spent making Carol and Frank look extraordinarily generous to everyone around them. Every over-the-top Christmas gift to a niece or nephew, every dazzling holiday spread that made relatives say, "Carol really does Christmas right." The secret unasked-for rescue of Frank's brother's failing restaurant, which bought them a permanent reservoir of gratitude and loyalty from that entire branch of the family. They weren't just stealing money. They were laundering it into social capital, using their son's inheritance to purchase, holiday by holiday, a reputation as the most loving, most generous, most essential family anchor anyone knew. And that reputation is exactly why, when we tried to set one small boundary about one single Christmas morning, the reaction was so explosive. It wasn't really about missing us at breakfast.
It was about a system they'd spent 6 years building. Mandatory closeness, constant surveillance dressed as love, extravagant generosity funded by someone else's money, starting, for the first time, to show a crack. We didn't just uncover a theft. We uncovered the actual mechanism by which the theft had stayed hidden for 6 years. The holidays weren't just cover, they were the product. Part of the settlement didn't require confidentiality on the underlying facts. Priya made sure of that, specifically because Daniel wanted his extended family to know the truth, not the sanitized version Carol and Frank would have spun. At a family gathering that following spring, one Daniel and I chose to attend specifically for this, Daniel calmly laid out the timeline, the forensic numbers, and the judgment to a room that included the very relatives whose loyalty had been quietly bought with stolen Christmas generosity for years. It did not go the way Carol and Frank expected. Frank's brother, the one whose restaurant had been secretly bailed out with Daniel's inheritance, was in the room. He left early and didn't speak to Frank again for the better part of a year. Carol and Frank are, as of this recording, largely estranged from most of the extended family. Not because of a dramatic falling out engineered by us, simply because once people saw the receipts, the most generous family in town reputation Carol and Frank had spent 6 years and $80,000 building collapsed under its own weight. People sometimes ask me what it felt like when the settlement funds actually landed. Honestly, it wasn't the euphoric moment you might picture. It was quiet. Priya's office sent a confirmation email. Daniel and I sat at our kitchen table and just looked at each other for a while. We didn't blow it. We didn't buy a lake house of our own out of spite, tempting as that would have been. Instead, the first thing we did was set up a properly structured trust for Poppy, this time with an independent, licensed corporate trustee, not a family member. Specifically so no relative would ever again have unsupervised discretionary control over money that belonged to one of our kids. We funded it with a meaningful chunk of the restitution and left the rest as a foundation for our own long-term stability, paying down our mortgage faster, building out retirement accounts we'd neglected during the chaos of the investigation, and putting a real emergency fund in place for the first time in our marriage. We also did something Priya recommended to every client in a case like this. We requested our full credit reports and placed a security freeze on both our credit files, specifically because forensic tracing showed Frank knew enough personal information about Daniel, social security number, date of birth, old addresses, to have theoretically opened credit in his name if he'd ever gotten desperate enough. He hadn't, but we weren't going to find out the hard way that he might.
And we built new holiday traditions, actual ones, chosen by us. A quiet Christmas morning at home, a Friendsgiving with the people who showed up for us during the ugliest parts of this, instead of a mandatory Thanksgiving built around obligation and image management. It took a long time, honestly, it's still taking time, to feel like holidays are supposed to feel joyful rather than like a performance review.
The vigilance part is ongoing, and I won't pretend it's fully resolved. Daniel still gets a small twist in his stomach every time a family member brings up the fund in front of new people, testing whether the topic is safe to discuss. We still monitor the judgment lien since Carol and Frank haven't sold or refinanced yet, and the interest is still accruing in our favor every single month they wait. But for the first time since he was 23 years old, Daniel actually knows where his money is. He can tell you the account number, the trustee's name, the balance, and the terms, because it's finally, genuinely, unambiguously his. I get messages all the time from people who watch these stories and recognize pieces of their own family in them. So before you go, I want to leave you with the actual pattern, the specific things that, looking back, should have told us something was wrong years earlier. 1. Family trustees who never provide statements. If a parent or relative controls a trust, an inheritance, or any account on your behalf, you are legally entitled to regular accountings in almost every state. "I'll handle it" is not an accounting. If years go by without a single actual document, that silence is the red flag, not a footnote to ignore. 2. Obligatory closeness that gets disproportionately emotional when tested. A normal relationship can survive one Christmas morning apart. If setting a small, reasonable boundary produces guilt, rage, or accusations of betrayal that feel wildly out of scale with the request, ask yourself what's actually being protected by that reaction. 3. Financial spending that doesn't match known income. Renovations, vacations, and extravagant gifts that don't line up with what you understand about someone's job or business are worth quietly noting, even if you never say anything out loud. You don't have to accuse anyone, you just have to remember. 4. A legal milestone that passes in complete silence. If you know a trust, inheritance, or legal transfer is supposed to happen at a specific age or date, and that date comes and goes without anyone mentioning it, that silence is information. People who are following the rules tend to mention the rules being followed. 5. Resistance to independent professionals. If a family member manages money on your behalf and reacts badly to the idea of you talking to the original attorney, the bank, or an outside advisor, that reaction is worth paying attention to. Trustworthy administration welcomes outside eyes. Fraud avoids them.
If any of this sounds familiar, here's exactly what to do, in order. First, request a written accounting, in writing, with a specific deadline. Email, not a phone call, so there's a record. Second, if you know the name of the original attorney who drafted the will or trust, call that office directly. They have an independent copy of the actual terms, the version that can't be quietly rewritten. Third, pull your own credit report and consider a security freeze, especially if the person controlling the money also has access to your personal identifying information. Fourth, and this is the hardest one, talk to a trust and estate attorney before you talk to the family member you suspect. Get your legal footing first. Confronting someone before you have documentation just gives them time to do exactly what Frank tried to do with that lake house. Move the asset before you can freeze it. And fifth, trust the disproportionate reaction. In almost every story like this one, including mine, the first real evidence wasn't a document. It was somebody getting far angrier than the situation called for. That reaction is data. Don't talk yourself out of noticing it. If you've been through something like this, a family member, a trusted friend, anyone who used closeness or obligation to hide financial theft, I want to hear about it. Drop your story in the comments. What tipped you off? What was the moment you finally knew something was wrong? And if this story kept you here for the last hour, do me a favor and hit subscribe, because there are a lot more of these. Real fraud, real investigations, real justice, every week. Thanks for watching. I'll see you in the next one.